Welcome back to Federal and Indian Gaming Law. Today we'll be going over the Wire Act, Part 3. Hopefully you had a nice President's Day away from class. And with that, we'll just kind of get back into it where we were before. Again, we're talking about the Wire Act, which again applies to those in the business of betting or wagering that use a wire communication facility for the transmission in interstate or foreign commerce of bets or wagers or information assisting in the placement of bets or wagers in any sporting event or contest, or for the transmission of a wire communication that entitles a recipient to receive money or credit as a result of a bet or wager, or for information assisting in the placement of bets or wagers. And we talked about the business of betting or wagering in the Barbarian case and sort of that test the Barbarian court applies. The Scavo court also applies that. Again, it requires the sale of a product or service for a fee involving third parties, customers, clients, or the performance of a function that's integral to the business. So pretty low threshold, but a meaningful one. Again, information assisting includes things like point spreads, account information, odds, the information a bookmaker uses to operate their business. And then we had the In Re MasterCard cases, the district court case, court opinion, and the Fifth Circuit Court of Appeals opinion that said, the Federal Wire Act only applies to sports wagering. Now, again, it did so in the context of a civil RICO action against the credit card companies for being part of a criminal racketeering enterprise based on the fact that they get a fee for each credit card transaction, including credit card transactions to process offshore bets, which are illegal. And the plaintiffs claimed it was illegal under the Federal Wire Act. Credit card companies said, no, the Wire Act only applies to sports wagering. Therefore, you can't hold us liable under RICO under the Federal Wire Act. Court agreed, but what was at stake was a lot for the credit card industry, that is. So what was the Department of Justice's view after In Re MasterCard? Well, they just said Fifth Circuit got it wrong. It's the Department of Justice's position that the prohibition applies to both sporting events and other forms of gambling. So on what do they base that argument? Well, it's based on interpretation of this language. And the question is whether sporting modifies event and contest, or whether sporting events are one thing and contests are another. So again, Department of Justice's view, that phrase, any sporting event or contest, means any sporting event, meaning sports wagering, or contest, which means any game with consideration, chance, and prize. The Fifth Circuit took the view that sporting modifies both event and contest. So it's any sporting event or contest, any sporting event or contest. So, and it does matter because it defines how broadly the Wire Act is going to be applied. And in the early 2000s, the Department of Justice, even into the mid 2000s, continued to have this view. Actually, as recently as 2010, when they took a plea agreement with a defendant that was involved in online poker, and he pled guilty to violating the Federal Wire Act in 2010. So the Department of Justice held this view. They testified before Congress that the Wire Act applies to all forms of online gambling. You have the Fifth Circuit as an outlier saying, no, it only applies to sporting events. But again, the Fifth Circuit really only looked at that first prohibition, and they never addressed anything after the word contest. Kind of see that in the prohibitions here? we actually have a series of comma orders, which brings us to Lombardo. Anybody read Lombardo? This one's a little bit near and dear to my heart because I worked with an attorney that represented one of the defendants in this case until they stopped paying the bill. Lombardo with others operates a payment gateway website through various businesses to fund better accounts on various online gambling sites. He primarily served the online poker industry. So bettors could add funds to their account through Gateway, and Gateway would miscode the transactions to avoid detection by other banks. Now, what should come through in this is that they had also corrupted a few banks in Utah, southern Utah, St. George area. Why you would pick Utah, I don't know. And he is charged with others with several violations, including Wire Act and RICO statute violations. Now, again, RICO requires sort of a predicate federal offense done in as a business. The predicate federal offense here was the Wire Act. And so, you know, Lombardo fights the Wire Act charge, at least, saying that the services are provided for online poker sites and not sports betting sites. So, you know, what then becomes the issue? And if you were his lawyer, would you make that argument? Sure, Courtney.
I think so, because there was already a circuit court that said that.
I saw maybe. No. Courtney, give it a shot again.
Yeah, can you hear me?
Okay, now I can, yeah.
Okay, good. I don't think it's a terrible argument just because there was a different circuit court. The Fifth Circuit Court said that, like, it kind of indicated that it would exclude poker sites and, oh, actually, yeah. Sorry, I'm mixing them up. So he's arguing that it doesn't cover sports betting sites, right?
No, he's arguing it doesn't cover poker and casino because his services were provided to online poker sites and online casinos. And therefore, those Wire Act charges should go away. And if the Wire Act charges go away, then the RICO charges should go away too, because there's no other federal criminal gambling law violation on which to base the RICO.
Okay, then yeah, like I was saying, then first the Fifth Circuit had taken the view that perhaps poker sites and casinos were not covered. So I think it's a fair argument to make.
Yeah, I think it's the best argument you have. And so the issue becomes whether the Federal Wire Act applies to just sports wagering activities or whether it applies to more. And what does the court do? Well, the court assumes the Fifth Circuit's correct in its analysis of the first prohibition. It doesn't concede that, but it assumes the Fifth Circuit's correct for the purposes of his 12b6 motion. But then it notes that the Fifth Circuit didn't analyze the second two prohibitions under the Wire Act, because you had that first prohibition prohibiting the transmission of a better wager information, assisting in the placement of a better wager, any sporting event or contest. But then you have another prohibition about the transmission of information entitling the recipient to money or credit as a result of a better wager. And then you have another prohibition on the transmission of information assisting in the placement of a better wager with no reference to sporting event or contest. So you have the exact same language twice, once with sporting bettor contest, once without. And so that's kind of what the court looks at then. And it says, well, the absence of sporting event or contest qualifier in the second and third prohibitions is conspicuous, especially as to the first prohibition, which includes the qualifier directly before the second and third prohibitions in the statute. And it goes on, the judge goes on to say, this is particularly weighty in light of the legislative history of the Wire Act, which indicates the intent of Congress to facilitate enforcement of state gambling laws related to gambling, bookmaking, and like offenses. Moreover, the exact phrase information assisting in the placement of bets or wagers is used twice in 1084A. First, as part of the first prohibition use, and second, as the entirety of the third prohibition prohibited use. It is simply unpalatable to the court to attribute meaning to Congress's use of the same phrase in two different parts of the statute, where the first is modified by the use of sporting event or contest, and the second is not. Accordingly, the court concludes that the second and third prohibition uses of a wire communication facility under 1084 do not require that the bets or wagers to which those uses relate be limited to bets or wagers placed on sporting events or contests alone. So let's go back, take a real quick look at that again. So I don't know if you can see the cursor or not. So again, you get to that first comma or, and then you have this or for the transmission of a wire communication entitles the recipient to receive money or credit as a result of bets or wagers. Again, another comma or, you have information assisting in the placing of bets or wagers. The exact same language you have up here. What the court really is saying is that we as statutory interpretation and construction requires us to give meaning to all parts of the statute. If this applied only to sports, then you wouldn't need the second information assisting. You have one with sports, one without. We assume they both have meaning. The only way to give them meaning is to say that the Wire Act first prohibition is limited to sports, but the next two are not. So this is kind of the breakdown again. So if you break it up the way Lombardo sees it, where you break it up with the comma ors, at those commas, you have that first prohibition with the sporting event or contest modifier. You have the second prohibition without, and the third prohibition without. Kind of see that? Take a minute to take a few moments to take a look at that. This is the same text we had before, just kind of broken out a little bit. So after Lombardo, we have some interesting outcomes. But let's take a look at the exemption. There is an exemption under the Wire Act. And that's in 1084B. And the first part of the exemption is for news reporting on sporting event or contests. But again, who does the Wire Act apply to begin with? Let's go back. Whoever being in the business of betting or wagering. So you have to be in the business of betting or wagering and in the business of news reporting or engaged in news reporting. Now, what gaming sector of the gaming industry or business would be involved in wagering and publishing news? Courtney.
Like bookies, like putting out odds and line information.
Yeah, that's not who it was aimed at. There is an industry that produces a fair amount of, or at least in the 1960s, produced a fair amount of copy around the product that they were offering. Anybody ever see a racing forum? It's like a newspaper almost. Identifies the horses, carries some stories about jockeys, lets you know who's in what race, that kind of thing. That's what this is aimed at. It's to provide some cover for tracks. So if you're the New York Racing Association and you want to have your racing forms printed, it may be a lot cheaper to print them in New Jersey or Connecticut than printing in New York. So you can transmit that information by wire to the printer, get those things printed and brought back. That's fine. So really the first exemption, I think, really was aimed at tracks. And there are court opinions that say this is for legitimate news reporting. You can't publish your lines as a bookie, throw a news story around it, and distribute parlay cards around the town. That's not legit news. You actually have to have some kind of a real news reporting function, and that would be tracks. Again, think back to 1961. You have one state that has commercial gaming. You have one state that has sports wagering that's legal and regulated, and it's illegal everywhere else. No state lotteries, no other outlets. So the only other outlet really is horse racing. And then we have the big exemption that gets misunderstood a lot. Or for the transmission of information assisting in the placing of bets or wagers on a sporting event or contest from a state or foreign country where betting on that sporting event or contest is legal into a state or foreign country in which such betting is legal. But look at that language carefully. What doesn't it exempt? And what does it exempt? So today's sports wagering is legal in New Jersey and Nevada. Can I get on the phone and call DraftKings in New Jersey and get my bet down on basketball game tonight based on this? The lines in Nevada are awful. But DraftKings has a great line in New Jersey. Alex.
I mean, maybe I'm just reading this incorrectly, but it seems like it's really only talking about the information assisting part rather than the actual like placing bets itself. Like that would still be prohibited.
Yeah, there's no exemption for cross-border wagering. And this gets misreported more often than I can tell you. And there are attorneys, particularly sports wagering law expert attorneys on the East Coast that continue to say, oh, well, if it's legal in both states, you can take bets across state lines. Like, no, I don't think so. And the legislative history doesn't say that. You know, let's take a look at that. This is a summary report of the bill written by the Attorney General of the United States in 1961, Bobby Kennedy, the guy that was pushing for this bill. And the purpose of the bill is to assist various states in the District of Columbia in enforcing laws pertaining to gambling, bookmaking, and like offenses, and to aid in the suppression of organized gambling activities by prohibiting the use of wire communication facilities, which are or will be used for the transmission of bets or wagers on gambling information in interstate and foreign commerce. Now, again, it's kind of interesting that they were kind of looking forward because they said which are or will be used for bets or wagers and gambling information in interstate commerce. So how did they come up with this distinction? Well, you can see it again here. And they start using the New York and Nevada example. Let's parse this out a little better. Same text, this slide and this slide are the same text, just this one gets highlighted. So in talking about the exemption contains two subsections. The first is for news reporting of sporting event or contest. And then B would exempt the transmission of gambling information from a state, to a state. And then what he says is phrased differently: the transmission of gambling information on a horse race from a state where betting on that horse race is legal to a state where betting on that same horse race is legal is not within the prohibition of the bill. So that gambling information, not the bets, are transmittable between those two jurisdictions. Since Nevada is the only state which has legalized off-track betting, this exemption will only be applicable to it. For example, in New York state, pari-mutuel betting at a racetrack is authorized by state law. I should say, for example, in New York state, pari-mutuel betting at a racetrack is authorized by state law. Again, at this point in time, New York didn't have off-track betting. You had to bet on the track. Only in Nevada is it lawful to accept wagers on a race held in the state of New York, where pari-mutuel betting is at a track is authorized by law. Therefore, the exemption will permit the transmission of information assisting in the placing of bets or wagers from New York to Nevada. On the other hand, it is unlawful to make and accept bets in New York on a race being run in Nevada. Now, at the time, there were no races in Nevada, so you can't take bets across state lines, but you can send information assisting. And what information assisting were they talking about at the time? Who's in the race? Who's scratched? When is the post time? Who are the winners? All that information, the odds you can transmit, because that's beneficial to both Nevada and New York's legitimate industries. And then finally, it says nothing in the exemption, however, will permit the transmission of bets or wagers or money by wire as a result of a bet or wager from or to any state, whether betting is legal in that state or not. So no transmission of bets, no wiring money for bets. And so let's take a look at the prohibition and the exemption side by side. So we get this. On the left side, we have the prohibition, section A. On the right side, we have section B, the exemption. So there's no direct correlation for news reporting on B and A. There's no prohibition on news reporting in A. So we go down to, there's no exemption for the transmission of bets in B. No exemption in B, but there is a prohibition in A. There's no exemption in B for the transmission of wire communication that entitles the recipient to receive money or credit as a result of a bet or wager. And then we have the more interesting one, because you have sporting event or contest applied to information assisting in the first part of that prohibition. You don't have it in the second, information assisting. And the exemption does have the modifier, which then begs the question, is the exemption only applicable to sports betting if the Wire Act is broader than sports betting, like the DOJ says it is? Good question. In 1961, it was probably mostly academic. It's not like you could play poker over the phone in 1961. You couldn't buy blackjack over the phone in 1961. Hey, I got blackjack. Hey, me too. You know. So it, post Lombardo, it makes it interesting. And we'll get into efforts to change the Wire Act, which have kind of subsided now. But let's take a look at the different interpretations of the Wire Act from the DOJ's point of view. So DOJ doesn't really say a whole lot about the breadth of the Wire Act until really 2001. And they did so in response to Nevada enacting what we call an interactive gaming statute. So in 2001, the Nevada legislature authorizes the Nevada Gaming Commission to regulate interactive gaming in the state of Nevada. And what is interactive gaming in the state of Nevada? We'll talk about this later, but in a later class. But what it really is it's online gambling. But back in 2001, you had a lot of different forms of what we'll call remote gambling or online gambling. Anybody familiar with Sky-B in the UK? It's kind of like DirecTV here. Familiar with DirecTV? Got a satellite dish, brings in a television signal. You've got a modem that sends information to them, so you can get things like pay-per-view, and you can get your card authorized for special packages like the Sunday ticket for NFL and things like that. So Sky-B had an online or a satellite TV-based Keno game in the UK. So we want to capture that. Another cable operator in the UK had a bingo game that ran through a cable box. We want to capture that. Another company, again in the UK, had a blackjack game, pay to play and win blackjack, on those flip phones. Remember the old flip phones? Little gray screen, and you can play blackjack on your flip phone. Was not internet based. It was based on GSM cell signals, so it didn't use any TCP/IP networking. We want to capture that, and we want to capture online gambling, internet gambling. So Nevada passes that enabling statute in 2001. In 2002, Department of Justice sends Nevada a nastygram saying, "Don't you dare. If you do, you, Nevada Gaming Control Board, and you, Nevada Gaming Commission, will be aiding and abetting violations of the Federal Wire Act, even on an intrastate basis." A couple of years later, Montana had a bill to permit online poker in Montana, and DOJ sent a similar nastygram to each member of the state legislature, warning them that they would, by authorizing that, they would be aiding and abetting violations of the Wire Act. So early 2000s, DOJ says Wire Act applies to everything. Now by 2005, though, online poker is huge, absolutely huge. And there are three really large companies that eventually go public in the UK. You had Party Gaming, which when it went public, after its initial float, it was, by measure of market cap, the second largest gaming company in the world behind MGM. So bigger than Caesars, bigger than Harrah's, bigger than all these other companies here. Party went public. Paradise, which was owned by, I can't remember, also went public. And you had the three companies that went public and went big. 2006, Congress passes the Unlawful Internet Gambling Enforcement Act, and the publicly traded online poker companies pull out of the US right after that, saying, well, while we thought the area was gray before, we think this clarifies the area, and as publicly traded companies, we can no longer participate in the US market now that it's been clarified. And we'll talk about this in another class. That's not what the UIGEA says, but they took the opportunity to pull out. In their absence, 3 new poker companies kind of took their place that were all private companies: Poker Stars, Full Tilt, and Absolute Poker. By 2009, the poker industry is lobbying full force in Washington. I had the privilege of working on a lobbying team for a Nevada casino operator in 2009, and we were going around and meeting senators and talking to them about a bill to make online poker legal in states that regulated online poker and allow for cross-border wagering between those states. Every place we went, you'd look and staff would already have either a Poker Stars bag and swag and water bottles, or Full Tilt swag, or Absolute swag. It's like everywhere we went, they had already been there. And that bill would have excluded them because it would have excluded anybody that was operating in violation of state law prior. So they were lobbying to be let in. And of course, everybody else is lobbying to keep them out. They shouldn't benefit from their illegal activity. About the same time, New York and Illinois decide they want to offer the sale of online lottery subscriptions to residents of their states. So not cross-state or interstate, but intrastate sales. So if you live in Illinois, you could buy a subscription to the Illinois lottery. If you live in New York, you could buy a subscription to the New York lottery, and you could do that online. And a subscription just means that, every so often you're buying a set of lottery tickets, and it's going to happen automatically. And they want to do this with using out-of-state payment processors, because payment processing, to be perfectly honest, in Utah and Nevada is less expensive than it is anywhere else. We have a low cost of living. Wages tend to be a little bit lower. Land costs are a lot lower. And that's what Illinois and New York wanted to do. They wanted to use banks here to process the payments for lottery transactions in their state. And so they sent a letter to the Department of Justice saying, it's our view that the Wire Act does not apply to this. And if you disagree with us, let us know. If we don't hear back from you, we're going to offer these subscriptions by the end of the year. And the DOJ does what it normally does with letters like that. It ignores them. They don't generally provide legal advice. So New York and Illinois offer those subscriptions. In the wake of that, New Jersey says, well, if New York and Illinois can offer the sale of a gaming product online in their state, we can do the same in our state. And they enact a law to permit online gambling within the state of New Jersey. And you know what the federal government does? They don't send them a nasty gram this time. Of course, between 2001 and 2009, we've had a lot of changes, right? Different administration, different Department of Justice. And in 2009, Department of Justice says nothing. In 2010, a compromise was reached on the federal online poker bill. And we think things are going to move ahead, but they don't. And we'll talk about that when we talk about online gambling. In response to New Jersey and now other states contemplating enacting online gaming legislation. Nevada modifies its interactive gaming statute in large part due to lobbying from illegal poker operators to compel the commission to adopt regulations to license online poker by January 2012. So we're going to move forward, even though we have that letter from 2001 or 2002 saying we shouldn't. 2011, Senators Reid and Kyle. I don't know if anybody know who Senator Kyle was from Arizona. Nobody? Fairly conservative senator, maybe very conservative U.S. senator from Arizona, a staunch opponent of online gambling. Anybody know who Harry Reid was? Not as conservative. Generally leery of online gambling as well, but they reached a compromise on that federal legislation in late 2010 regarding online poker. And they sent a letter to the Department of Justice saying, Department of Justice, please issue an opinion stating that what New York and Illinois are doing is wrong. Now, why did they do that? Because their online poker bill also contained a provision that allowed the lotteries to do exactly what they were doing. And if you get the Department of Justice saying it's illegal to do what you're doing, then they have to come in and support the bill so that they can go back to doing what they're doing. Right? Politics. And they weren't off base because, the Department of Justice sent Nevada a letter like that back in 2002 and sent one to Montana, not, a couple of years later. I can't find my copies of those letters, but eventually I will. And going into, the summer of 2011, this is kind of where things stood until December 23rd, 2011, when the Department of Justice issues its first actual formal opinion interpreting the Wire Act. I happened to be on a flight from Nevada to Chicago at the time. And when I landed, from the time I took off to the time I landed, the Department of Justice released the opinion. It actually has a September date on it, but they didn't actually publish it until December 23rd when, everything's closed for Christmas. So what does it do? Well, it addresses the Illinois New York letter. Woohoo! A couple of years later. Now, a little backstory on it. This comes from the Office of Legal Counsel. And one of the primary authors was an attorney that prior to working at the Department of Justice worked for a law firm that represented poker stars. A little background on that. Poker Stars was going around to prominent law firms, and she was from a prominent law firm, requesting federal Wire Act opinions on poker. Nothing else. Can't talk about anything else, just the Wire Act. And they were paying top dollar. And they came to the firm that I used to work at, Lionel Sawyer, and they were offering us rate plus to do the letter. Because it was a pretty, when it came to gaming law, that firm carried some weight. We ended up turning it down. Could have used the money because, again, 2011, the economy is still not great. But the constraints that they put on us, we didn't think it would be an honest and fair picture of federal gaming law risks for online poker. So anyway, one of the authors may have had a hand in authoring a letter from a very large New York firm on this at one time. But they do answer the letter of Illinois and New York. And first thing they say is, you know what? We find tension with the Unlawful Internet Gambling Enforcement Act and the Federal Wire Act. And they do because, taken together, the interpretations would lead to the conclusion that even intrastate wagering is illegal. And that's not the scope of the Federal Wire Act. You know, it's an interstate and foreign commerce. And then they also note that reading the Wire Act in that way to apply to intrastate transactions really does create tension with the UIGEA, saying that the Wire Act may criminalize conduct the UIGEA suggests is lawful. Okay. But then they go on to say we really don't have to address that today directly because the Federal Wire Act only applies to sports wagering. And they go back and they look at the legislative history, but only a portion of it. By the way, with the Federal Wire Act, you can look at the legislative history to support almost anything. Austin, you have a question?
Yeah, so in 2001, was the DOJ, could you remind me, did they say that Nevada's interactive gambling statute was against the Wire Act or the
Yes.
UIG, so not the other statute?
Yeah, the UIGEA was enacted in 2006, so they sent the letter long before the UIGEA was ever enacted.
And so it was going to be against the Wire Act, even if Nevada kept it within Nevada's border?
That was the view of the Department of Justice. So it came from Bush 2 DOJ.
Was it because it was online and they just didn't believe that it would stay within the borders?
They didn't explain a whole lot. They just said all online gambling violates the Federal Wire Act. Therefore, if you regulate it, you're aiding and abetting that activity that's under the Wire Act. And they didn't really go into much of an analysis. Now, if you know the history of Nevada gaming, and I guess we can go into that a little bit, because that may put some context around this. Nevada historically, when we became a state, we were a really small state, population-wise. In fact, we were the smallest state in the nation by a pretty good margin, but we were the fourth largest state area-wise. So we're a big state with a little population, and most of what drove the Nevada economy was mining. And you know what kind of people engage in mining? Of course, back in the 1860s, I think it's well-educated women. So what do you think the average profile of a miner looks like? Courtney?
People that like to gamble.
Yeah, it's usually single guys or people that have left their families behind. They're out in the West. It's rugged. They're generally lawless. And gambling is popular. So we become a state. Gambling is actually legal. We become a state, but within a few years, I think it was within 4, it was legalized and regulated by local sheriffs. But Nevada really didn't have any tourism industry. I mean, you got to remember, this is in the late 1800s, early 1900s. There's no air conditioning. People travel by horse primarily. And Nevada is inhospitable. It's just not. You're not here unless you want to be here. You're not taking a vacation here, particularly Southern Nevada. But in 1909, we make gambling illegal. We bring it back in 1931 because of the Depression, but we bring it back the way we did it in 1908, which is sheriffs regulate and collect fees. And it kind of works because it was just a vehicle for funding local government. But what ends up happening is a number of the sheriffs get corrupted They stopped collecting fees for the county and maybe are collecting fees for themselves. The legislature is getting upset, and they try to prod sheriffs to collect the quarterly license fees. Now, the requirement for a license was you had to be a U.S. citizen. That's it. So from 1930 really until the early 40s, that's kind of how it worked. And then two inventions come along in the early 40s that really change everything for Nevada. Anybody take a wild guess as to what they were? I gave a clue before.
Air conditioning.
Yeah. And automobiles. Even if you have air conditioning, it's a long horse ride from LA to Las Vegas. So those two things caused the population in Southern Nevada to triple between 1941 and 1945. Now, again, you have no state tax of gaming, and the only requirement is you have to be an American citizen to get a gaming license. So there's no state income tax, no state gross gaming revenue tax, little to no regulation. Gambling is still considered a pariah activity, an extreme vice. So you can't go to a bank and get a loan for a casino project. So who do you think it attracts? Well, it attracts people with alternative sources of revenue for investment. And it attracts people with gambling convictions in other states that, you know, have some experience in running gambling games. So it attracts some legitimate developers and it attracts some less than legitimate developers. Finally, by 1945, though, the states had enough of the sheriffs not collecting fees, and we imposed a 1% gross gaming revenue tax. Now, that then puts the Nevada Tax Commission in a somewhat regulatory role for gaming in 1945, but its role is really limited to collecting the tax and issuing a state license. And we had some events occur in Nevada that made headlines nationally. So, you know, in the mid 40s, you had a casino in Tahoe, the Tahoe Village Casino, that was owned by two guys. And one of the owners got shot on the casino floor in public and killed on the casino floor. Nobody was convicted, by the way. So you would think there would be plenty of witnesses, but apparently not. And then you had the Flamingo Hotel that was $1 million project by Ben Siegel, who was involved in RaceWire information services prior and had ties with organized crime. But the Flamingo ballooned to a $6 million project. Nobody's quite sure where the money came from. But the speculation is that the contacts he had were funding the Flamingo development were unhappy that the costs ballooned by a factor of 6. And he was shot and killed. And you get a lot of news stories coming out of Nevada that are pretty salacious. And in response, the Attorney General at the time issued an opinion saying the Tax Commission inherently had the power to look into the character of applicants for a gaming license, but didn't say a whole lot more. And the Tax Commission didn't have staff to really regulate gaming. So that opinion comes out in 47. But at the time, Tax Commission has one accountant dedicated to gaming and one inspector. And there are thousands of gaming operations in the state of Nevada. So they used their newfound power in 48 to deny 5 licenses while granting over 1,000 others. Again, they have no resources to do background checks. In 49, the legislature gave the gaming commission, or the tax commission, more power to look into the background of applicants formally and to pass regulations to that effect. And what the gaming commission or the tax commission did is they required everybody in gaming to get fingerprinted. And that was kind of a watershed moment because a lot of people in gaming left for fear that they would be arrested on outstanding warrants in other jurisdictions. So we got rid of a lot of criminals that way. But the news kept coming out of Nevada, and most of it wasn't good. In the 50s, you saw the Kefauver hearings. We talked about the Wire Act. You had an attempt by Congress to actually put gaming out of business here with something called the wagering excise tax. And by 1960, it was looking pretty bad. And it looked worse once we realized that Robert F. Kennedy was going to be the Attorney General of the United States, because Robert F. Kennedy was counsel to a number of these Senate commissions that went after organized crime. And he got into shouting matches with a lot of criminals, people like Jimmy Hoffa, and the Teamsters actually funded a lot of casino development here. So when Jack Kennedy was inaugurated in 1961, the very next day, he appoints his brother as the Attorney General, and he gets approved, or gets the consent of the Senate, and the appointment's confirmed. And by May, he asks the Attorney General of Nevada to deputize 50 agents as federal agents, and he's going to raid the casinos in Nevada and shut them down. Now, simultaneously with this, in 1958, a guy named Grant Sawyer gets elected governor. He's from Elko. He's kind of a progressive Democrat, and he uses all the political capital he can muster to get the Modern Gaming Control Act passed in 1959. What the Modern Gaming Control Act did is it took gaming regulation away from the tax commission, created the Gaming Commission, Nevada Gaming Commission, took the Gaming Control Board out from under the tax commission, made it an independent agency, fully funded it, gave it broad powers, and by 1961, everything was kind of in place, but now there's this threat that the feds are going to shut everything down. And that's the reason Grant Sawyer pushed for this, was to keep the feds out. And so he flew to DC to talk to Bobby Kennedy. Bobby Kennedy didn't see things Grant Sawyer's way. Grant was worried that shutting down the industry would have a devastating effect on Nevada's economy. So he went and talked to his friend John, who he had supported early in the primary process for the 1960 election. And John Kennedy gave him the time he needed. So our regulatory system in Nevada was really built to preserve the industry and keep the feds out. So in 2002, when the federal government, the Department of Justice, sent us a letter saying, "Don't you dare do this," you know what we did? We stopped all efforts. So, that may provide a little context on that 2002 letter from the Department of Justice, why we stopped, and the federal government really didn't like what was going on out here. Now, again, 1961 is a lot different than 2002. Gaming is a legitimate industry in many states. In fact, you can find some form of legal and regulated gaming inside of all but 2 states. So things have changed a lot, but our regulatory structure was designed to preserve the industry, legitimize the industry, because it's a vital part of the Nevada economy. And part of doing that is keeping the federal government from shutting us down and keeping Nevada out of the headlines for bad news. We don't want more congressional hearings. We don't want a mass of deputizations to shut casinos down. So we backed off in 2002. But back to the 2011 opinion. The DOJ says, you know, sporting modifies both event and contest. We were wrong. You know, we've gone back, we've really taken a good look at it in light of the letters from New York and Illinois. And we think that the Federal Wire Act only applies to sports wagering. Therefore, New York and Illinois, go ahead and do what you want to do, which they were doing anyway. Again, the history of New York and Illinois is a lot different. They never had a threat of the federal government coming in and shutting down the largest industry in their states. So, a little different history. So that's what happens. You get that Wire Act opinion coming out in 2011 that basically says sports only. Sports wagering only. And it alludes to the fact that the intrastate wagering is not the subject of the Wire Act either. You know, this is based upon the Commerce Clause. Therefore, it's just interstate, and foreign transmission, like the text says. So your Kent is wrong. But not everybody's happy. And let's take a look at this.
Right now,
can you hear this?
Reputable gaming interests are lobbying hard to spread internet gambling throughout the country. If they get their way, gambling will be available in every home, every bedroom, every dorm room, on every phone, tablet, and computer, everywhere, 24/7. Targeting families, kids, the elderly. This isn't a game. The FBI warns that online casinos are vulnerable to a wide variety of criminal schemes. While the FBI is busy defending against terrorist threats and cyber attacks, internet gambling will give criminals across the world a foothold in every American household, attracting criminal activity not only at home, but internationally. Gambling without borders, making it ridiculously easy to launder money for crime syndicates, even for terrorist organizations, and providing easy targets for identity theft. An established Al-Qaeda poker network could extract enough untraceable money from the United States in just a few days to fund several 9/11-sized attacks. The FBI's job is tough enough. Why make it easier for organized crime and terrorist groups to operate in the U.S. and threaten the safety of law-abiding citizens? When the online games begin, that's when the trouble starts. Don't let it happen here. Say no to internet gambling.
Ooh, pretty scary, huh? Al-Qaeda Poker Network. This was a grassroots organization funded by one person in particular. Anybody care to guess who? He's passed on, but he was a big donor to one party in particular, political party in particular, and his company actually did engage in online gambling out of Alderney at one time. Courtney.
Yeah, was it? Oh my gosh, Sheldon Adelson.
Yeah. But his view was that online gambling would be cannibalistic to land-based gaming, and he had large investments in land-based gaming, and I get that. I mean, I get the argument. The data from New Jersey says otherwise, but I get it. So he funds a grassroots effort. He also makes a lot of donations politically. And he's pretty successful at that. So, he supported the prior president and members of that party. And eventually we had one party rule in Washington, D.C. for quite a while. And So Congress took it up in earnest.
Thank you. Thanks for being here. I'm Congressman Jason Chaffetz, and it's an honor to be with you. Today is my birthday, and so I've got to say hi to my wife Julie, and appreciate her. And I dreamt of nothing more than spending my birthday with Lindsey Graham. Yeah. That's just a dream come true. So does everybody else. Yeah, thanks. Listen, we are here in a bipartisan, bicameral way to introduce the Restoration of America's Wire Act. Back on December 23rd of 2011, the Department of Justice issued what it believed was the right interpretation of a long-standing Wire Act that had been around for more than 50 years. Those of us that are signing on to this piece of legislation simply want to restore the Wire Act to its interpretation pre-December 23rd of 2011. We're not trying to make other alterations. There are those that would argue that internet gambling should happen in a broad stroke. Some believe that internet gambling should happen just for poker. If there is a case that people want to make for online gambling, they need to come to the Congress. The Congress could or should debate this, and then perhaps that piece of legislation would ultimately pass. I personally would be against that. Being from Utah, we're one of two states that has no form of gambling. This is a very important issue to the state of Utah, to the people of Utah. Nevertheless, what we're saying with this piece of legislation, the Restoration of America's Wire Act, is that it should not be a single person in the bowels of the Department of Justice reinterpreting the law and fundamentally changing the landscape. That is not the way the process should work. These types of things should be debated and discussed in the United States Congress. And then, if appropriate, a vote would happen. But to simply have an individual in the bowels of the Department of Justice unilaterally making this change, we believe it's wrong. Now, we have heard from attorneys general from across the nation. More than 12 have written to us stating that this is a problem. We have several governors that have said that they believe that this is a challenge. You have the FBI, who has also weighed into this, believing that their money laundering and other types of unintended consequences will happen through this process. So we're trying to do that. Again, we're doing so in a bipartisan, bicameral way. We have 10 co-sponsors in the House.
For $10, you can enter a pool to guess how old Jason is and not violate the Wire Act. So this is bipartisan in the Senate, and I can promise you this: if a Republican Attorney General's office came up with this interpretation, I would be standing here. That's the point. To say that the Wire Act, after 50 years, only applied to sports betting is an incredible legal stretch. It changes fundamentally the statute, as Mike said, in Latin. I'll say in South Carolinian, it screwed everything up. It really did. It destroyed the statute. And if you want to have online gambling, then come to the Congress and see if we'll vote for it. If you want to have a poker exception, as Jason said, offer an amendment, see if it will pass. This is not just about gaming. It is really about the process. So the Attorney General's office, in my view, made a huge legal misstep here. And those of us in Congress who are worried about the effects of online gaming are going to push back. And those who feel.
So you kind of get the idea. So what did the Restoration of America's Wire Act actually do? It was not just a restoration. It was an expansion, a significant one. So the first thing it wanted to do was remove the phrase sporting event or contest in the prohibition section. Then it wanted to define an interstate transmission to include any use of the internet where packets could incidentally cross state lines. So it would apply to intrastate wagering as well. And then, oh, how about that? It would exclude fantasy sports wagering. Why would you do that? Well, maybe somebody wanted to make an investment in fantasy sports wagering. What does that have to do with the Wire Act? Nothing, but So what does that really do then? Well, let's take a look at it. Well, here's based on the pre-2011 view of the DOJ. You know, this is kind of a flow chart. So if you have an issue, you look at it, you say, you know, is somebody in the business of betting or wagering? Yes or no? No, no Federal Wire Act application, yes. Then you look at, is there a transmission of a better wager on any sporting event or contest? Yes, Federal Wire Act prohibits it. Is there, no, well, is there a transmission of information assisting in the placement of bets or wagers on any sporting event or contest? You know, again, if not, then no Federal Wire Act violation. If there is the wagering on the sporting event or contest legal in each jurisdiction? If it is, then it's under the exemption. If it's not, it's a prohibition. Kind of see how that flows? Now let's take a look at if RAWA is enacted. And are you in the business of betting or wagering? Same. Is the transmission on fantasy sports? If yes, then it doesn't apply. If it's not, then is there a transmission of any better wager or information assisting across state lines? Yes. Or across a wire communication? Yes. Then it's a violation. Is there a transmission of information assisting? You know, no Wire Act violation. Yes. Well, here's the catch: is that information assisting is only exempted if it's sports wagering, because the Restoration of America's Wire Act wouldn't touch 1084B. So if it's not about sports wagering, then even the transmission of information assisting is illegal, and it also violates the Federal Wire Act. So let's look at this. So you have mobile casino gaming with a remote server on an intrastate basis. Anybody familiar with mobile gaming? There are a few casinos that have it. You can bet, you know, blackjack, baccarat, things like that on your phone with the casino, in the casino environment. So are you in the business of betting and wagering? Well, yeah, if you're a casino operator, you are. Is there a transmission of fantasy sports bets? No. So continue down. Is there a transmission of a better wager over any communication medium? Yeah. Oops. Federal Wire Act prohibits that under RAWA, if changed. Well, what about system supported slot gaming? Anybody familiar with system supported slots? Aria has this. There are a couple other casinos that have it. There's been a move to try and implement this in more places. It's where the slot cabinet is basically an input-output device, and the games are actually run on a server. Now, what does this let you do as an operator? It lets you change the games out without moving the boxes around. So, you know, Cops and Donuts might be hot today, but next week it's Goldfish. So rather than reeling out the Cops and Donuts boxes and bringing Goldfish boxes, we just change it on the back end. Well, Goldfish isn't popular anymore. Now it's Triple Buffalo. Now Triple Buffalo isn't popular anymore. Now it's Golden Buffalo. So, you know, for a lot of reasons, this makes a lot of sense in the casino industry. Now, for places like Aria that were built in the mid-2000s, it's easy because they have data centers built in. But what about places like the El Cortez? Are you familiar with the El Cortez? Think they have a nice data center in there? No. Wasn't built with a data center in mind. So what Nevada did is it said you can run these servers at an approved location with approved communication lines. So what happens then is you run dark fiber between like the El Cortez and Switch, and the servers are off at Switch, which is just south of the 215. I think it's near Jones. But the boxes are at the El Cortez downtown. So let's see if it makes that illegal. Are you in the business of betting or wagering? Hypothetically, the El Cortez, yeah, you are. Is it fantasy? No. Is there a transmission of a better wager over a communications medium? Well, if the device only is getting graphics and things like that, but the RNG is on the device, probably not. But is there information assisting? Yeah. Is it sports wagering? No. Well, that would violate the Federal Wire Act. Now, the last one was system assisted. This is system based. This is where the RNG is actually on the server. Same idea, not fantasy. Is there a transmission of a bet? Yeah. Violates the Wire Act. So RAWA is a big expansion. What about remote sports betting? Anybody have a sports betting account? All right, anybody with a sports betting account where they can bet on their phone? Well, you're in the business of betting or wagering? Let's use Caesars or MGM or anybody for that matter. Yeah. Is it fantasy? No. Is there a transmission of a bet over a communication medium? Yep. Remote sports betting in Nevada would be illegal under RAWA. Megabucks. Anybody familiar with Megabucks? Kind of getting the idea here, right? Not fantasy, transmission of a bet. No, just information assisting. It's a progressive. Information assisting, absolutely. Is it sports wagering? No. Under RAWA, it violates the Federal Wire Act. Powerball, same thing. For lotteries, information assisting, it's not sports, violates the Wire Act. Anybody familiar with how the high-end gaming market works? So hypothetically, you have a foreign national wants to come to Nevada and bet, I don't know, $50 million in a weekend. You think they just kind of like walk through the door? Say, hey, I got $50 million. I'd like to start betting. No. What do you think they do? Well, Austin.
They sign a marker, don't they?
Yeah, they will sign markers. But usually even before that, what they're going to do is they're going to get in touch with a casino host. Because rich people know about casino hosts. And they're going to say, what can you do for me? I want to come in with $50 million. What are you going to do for me? And they're going to say, well, you know, $50 million, we'll put you up in high roller suite. No, of course, no charge. I was lucky enough to see one of these, actually a few of these. You know, the mansions at MGM are pretty amazing. The high roller suites at Venetian Palazzo are amazing. I was in one, it was 27,000 square feet. It's crazy. We'll put you up there. We'll give you a butler or two. You know, we'll send a chef up to your room when you want to eat. We'll schedule time for you in the gaming salon. And in exchange, you'll put 50 million behind the cage. We'll give you a marker for 50 million. And you're going to bet X, you know, let's say his game is roulette. You're going to bet X per spin on roulette for X number of hours per day in exchange. And they actually sign an agreement for that. Because you know, it's not inexpensive to put somebody up like that and to cater to them. You know, they may give them some spending money at the mall or their significant other or traveling partner. You know, may get exclusive access to high-end shopping, things like that. So, how do these things occur? Well, they occur by negotiating over the phone or email. So, is the casino in the business of betting or wagering? Is there a transmission of a bet? No. Is there information assisting in the placement of bets or wagers? Boy, you sure as heck hope so. Uh-oh. Is it sports wagering information? No. We got a problem. and this is part of the problem. I think a lot of times the lobbyists or the people in government affairs don't know how your business works. And so the person that was funding the RAWA effort, I don't think had any clue that the bill they were proposing would easily be interpreted to make their high-end gaming business model illegal. You're sending an agreement in interstate commerce to bring somebody in to spend $50 million. Is that as helpful to your, is that as necessary to your business, your high-end business, as lines are to a bookie? Yeah. So the hearings are a disaster for RAWA. I mean, an absolute unmitigated disaster. And it never goes anywhere. But story's not over. Let's get back to Lindsey Graham, and then we'll cut it after this video and we'll pick it up. We'll finish up the Wire Act on Monday. So let's take a look at this exchange. Now, on the left, you have Jeff Sessions, who has been nominated to be the Attorney General of the United States. He's currently a senator from Alabama. And you've got Senator Lindsey Graham from South Carolina, who's going to ask him some questions in his confirmation hearing. So let's listen to this.
What's your review of the Obama administration's interpretation of the Wire Act to allow online video poker or poker gambling?
Senator Graham, I was shocked at the memorandum, I guess the enforcement memorandum that the Department of Justice issued with regard to the Wire Act and criticized it. Apparently, there is some justification or argument that can be made to support the Department of Justice's position, but I did oppose it when it happened, and it seemed to me to be an unusual.
Would you revisit it?
I would revisit it, and I would make a decision about it based on careful study, rather than, and I haven't gone that far to give you an opinion today.
Immigrant.
So for Lindsey Graham, this tops immigration, by the way.